Oh, Bronco Nation, welcome back for another look kind of inside the world of athletics and business and the ever-changing landscape of the really legislation surrounding collegiate athletics. My name is Garrett Jones. Great to be here with you again, as always. I'm joined by Sam Ehrlich, who is an assistant professor in the College of Business and Economics here at Boise State. But he's really taken on something much more within that landscape that I was talking about in sports litigation, sports law, sports business. Sam, thanks so much for coming on. First off, how are you doing today?
I'm great. Thank you so much for having me, Garrett. I'm happy to be here.
We're thrilled to have you. And really the hinge point of what we wanted to talk about today is related to the current litigation regarding the House bill and the NCAA and in the NCAA student athletes. We'll get to that later. But first, like I said, you kind of stand out within this realm because of what you've done on social media and through the internet and really not only developing this issue, but letting fans know what the heck is going on because it's so ambiguous, so many moving parts. Let me start by asking you, how did you first get interested in sports and then sports litigation particularly?
Yeah, so I've always been really interested in kind of the behind the scenes of sports. I've really found all that stuff fascinating. In fact, kind of going back when I was growing up, July 31st was always my favorite day on the calendar for two reasons. One, it was the baseball trade deadline, and it was always really fun to kind of track all that and see what's going on with all that. And then two, it was kind of secondary. It's my birthday, so.
That's a good birthday.
It's a good birthday.
MLB trade deadline.
Yeah, it's a good birthday, but all that stuff is really always fascinated me. So when I went to college, I was able to go to University of Massachusetts and their amazing sport management department. So I got my bachelor's in sport management from UMass, and then went to law school, also kind of focusing on sports law because when I was at UMass, I got a chance to take a sports law class with a guy named Glenn Wong, who is one of the titans in the sports law field. And I just loved every second of it. Got to do an internship, or got to do a research assistantship with him, which led to an internship with the Jets, and just the legal aspects of sports, kind of the behind the scenes of all that, kind of the way that, and especially looking at college sports, the way that the law interacts with with sports in particular is just absolutely fascinating to me because it's so radically different than how the law interacts with traditional business in a lot of really interesting ways.
Yeah, and I mentioned the recent development of something that you've done over the past couple of years as there's been, just cataclysmic changes in collegiate athletics. Specifically, you go back to 2021, the introduction of name, image, and likeness rules, the current set in the NCAA. You started a case tracker on the internet through your social media. You've been promoting it. What led to that, and how much fun are you having, updating that right now?
Yeah, I mean, that website, the College Sports Litigation Tracker, it was kind of a funny thing where I was talking with my good friends, Joe Sabin and Neil Turnus, who are professors at other schools. Joe's at Southeastern Louisiana, Neil's at Northern Illinois. And we were talking this the whole time, and I had similar conversations with journalists in the field about it would really be nice with all the litigation that's going on against the NCAA and kind of that shifting college sports in so many different radical ways, especially since the Supreme Court's decision in Alston and kind of the tangential cases that kind of arose out of that. It'd be really nice to have a website that kind of had all the documents in one place. Like, as I like to joke around with Joe, and I think he's usually the source of this. I built the website because I got annoyed of him asking me for documents because I kind of kept track of everything and kind of just on my own. And he'd always ask me for stuff, and I'm like, let me just build a website so you can get everything there. But no, I mean, it was really something that I built for my own personal research. Right. All my research is focused around the legal aspects of college sports and kind of these emerging cases in college sports. And I actually had it available to myself for a few months before I actually released it, and I just got so much positive feedback on it. Like people were really appreciating it, and which was flattering to me because it was something I really built for myself and my friends. Yeah. That I decided to release it, and I've been blown away by the positive feedback I've gotten on it.
And you become somewhat of an authority kind of on this issue and with pending case litigation. Actually, separately from researching for this podcast, I was looking up an NCAA baseball player, and I saw a reference or a website that referenced your tweet talking about the pending litigation that he had. So this is a serious authority, Bronco fans. So I say all that to say part of the reason why we wanted to have you on today was to explain to Bronco fans who maybe, love Boise State athletics and pay close attention to their teams, but might have heard the term over the past 4 years, like NIL, like pending House litigation. like the April 7th settlement deadline, right? They might have heard these things. The revenue sharing, Bronco Pro. I mean, I just threw out 5 or 6 different names. And by the way, if you want to hear more on Bronco Pro, be sure to check out our recent episode with Athletic Director Jeremiah Dickey and new Deputy Athletic Director Cody Gogler, wherever you may listen to this podcast. But all that to say, Bronco fans might have heard these kind of ambiguous terms over the past couple of years and might have had, I'll look into that later, or maybe just don't have a good understanding of that. I think the one thing that we wanted to focus on today was the NCAA House bill, and that's kind of the colloquial term. So if you can boil it down to the main things that Bronco fans need to know about that, generally speaking, what is that and how does it affect collegiate sports today?
Absolutely. So the House settlement, the kind of what we kind of collectively call as the House settlement is a legal settlement, it's a class action settlement that looks for the NCAA to settle 3 different cases: House v. NCAA, Hubbard v. NCAA, and Carter v. NCAA. 3 antitrust cases that have challenged kind of 3 different areas of NCAA rules, and all about kind of like to try to drill down antitrust law into a few sentences. Essentially, all about kind of this argument that the NCAA, through its rules, through its amateur rules, has restricted the competition for college athlete labor and has kind of pushed down the prices of college athlete labor just through not allowing NIL for a very long time, still at least until the House settlement was approved, not allowing universities and colleges to pay athletes directly for things like broadcast NIL, the NIL that they have for their broadcaster for broadcaster and for showing on TV, and just generally speaking, the amateurism rules that the plaintiffs have argued that but for these amateurism rules, but for this concept of amateurism, college athletes would be able to get paid and be able to get paid handsomely, which is something that we're seeing for sure in kind of this new market. So the House settlement settles these 3 cases. It settles House, it settles Hubbard, it settles Carter. And it does so in really 2 different ways. The first way is through back damages, where athletes from 2016 to when the settlement was approved will get money in terms of back damages from a pool of $2.576 billion. So a healthy amount of money. And the second area is through what we call in the law injunctive relief, where essentially the court is going to impose through the settlement this injunction, this court order that will force the NCAA through their agreement to make certain rule changes. And these rule changes will be, 1, allowing for revenue sharing, where universities can share revenue, can pay their athletes directly up to a cap of 20% of shared athletic revenue between looking at the Power 5 schools and Notre Dame. 2, which is approximately, I should say, it's approximately $20.5 million per year. 2 will be through kind of the implementation of roster limits, which will replace scholarship limits. So instead of having, for example, in football, you could have up to roughly 130 football players, including a number of walk-ons. You can only have 85 scholarships. Now it's going to be a straight 105 roster, but you can have 105 scholarships. You can have scholarships up to the roster cap instead of kind of having an arbitrary number below that limits how many scholarships you can give. So that's the roster limit part of it. And then finally, the NCAA would be empowered to enforce third-party NIL rules, kind of restrictions on athletes being able to get third-party NIL, and to be able to do so in ways that would really restrict booster payments from what they consider associated entities and individuals, as they call it in the settlement, and make it so that those deals have to be, 1, for fair market value, and 2, for a valid business purpose. So those 3 injunctive rule changes are really kind of what the light switch that's really going to be flipped when we kind of get through this April 7th date.
Yep, and you went right to it. I mentioned that date a couple times, April 7th. That's the final hearing, correct, on House v. NCAA. So what can fans expect to, I guess, start the gears in motion, right? Is there anything immediate that's going to be a result of that final hearing, or do you expect it to kind of go on for a few more months after that?
It'll be interesting. It's one of those things where when we're talking about class action settlements, we're talking about a standard that it has to be fair and reasonable to everyone in the class. And there's a number of arguments saying that the settlement isn't fair and reasonable, that it sets an arbitrary cap on revenue sharing, where why are we limiting it to $20.5 billion? Why aren't we having kind of a broader free market overall? The roster limits have been a huge source of concern for a lot of people because it's really kind of pushing universities, pushing athletic departments to be able to have to cut a number of players to get down to those newer roster limits, which in a lot of cases are smaller and are less fluid than you'd be able to have walk-ons beyond those numbers. Now you can't, and there's really just a lot of kind of objections to the settlement. There's going to be I think 11 witnesses testifying, saying on April 7th, testifying and saying that the House settlement shouldn't be approved. But it's one of those things where it's in the hands of one person. It's in the hands of Judge Claudia Wilken of the Northern District of California, and she's going to be the one who decides whether she feels it's fair and reasonable. There might be appeals after that, but it's really going to be in her hands. It's going to be kind of up to her to decide. But based on the preliminary approval hearing that we had several months ago, and kind of the way she handled some of those objections back then, I would expect it to be approved. It may be something where she kind of pushes the parties to make a few changes, but I would expect it to be approved.
Do you think it is fair to say that April 7th is kind of the official/unofficial start of the revenue sharing era in collegiate athletics?
I think that's very fair to say. I think that it's really a good way of putting it, because once that settlement is approved, whether it's on April 7th or maybe a few days later or a couple weeks later, that's going to kick off revenue sharing. And even if the settlement isn't approved, there is kind of some rumors out of the NCAA, some thoughts out of the NCAA, and honestly, I think it makes sense given they know and given how schools have kind of geared up for revenue sharing already. I would imagine the NCAA, even if in the off chance the settlement isn't approved, which is possible, it could happen, but if it isn't approved, we're probably going to see some form of revenue sharing anyway.
Absolutely. So based off of that, I understand that there's a current formula that they have in place for revenue sharing, and you referenced it slightly there in your last answer, but if you can explain to our audience, what is that current formula and how was it developed?
Yeah, so it's going to be really what Kessler and Berman, the two lead attorneys for the plaintiffs in this case, what their goal is. Kessler is a big collective bargaining guy. He's a big labor law guy. He's represented the NFLPA, the NBAPA, the MLBPA, all these different unions in collective bargaining agreements and kind of collective bargaining disputes. So what he has in his head is kind of similar to if you follow collective bargaining disputes between the professional sports leagues and their unions, there's always kind of this goal, like we want to have 50-50 revenue split. We want to have a split between revenue between the teams and the players of roughly 50-50. And sometimes it's a little malleable, but that's really the goal here. So the way that Kessler and Berman really approach this, from what they've been saying and what they've written in their various briefs defending the settlement, is they're looking to have this 50-50 split. So the way they calculate it, and the way that Dan Rasher, their expert witness economist, calculated it, is that when you include not only the revenue sharing, the 20% revenue sharing that is going to be allowed, when you include that along with scholarships and other benefits that college athletes receive, that payment to athletes, kind of that whole conglomeration, the cost of all that, will equal roughly a 50-50 split.
Let's talk NIL for a little while, if you can. Of course. How does NIL kind of, as a collective as a whole, talking maybe school collectives, how does that differ from the House settlement? And if not, how will it affect those NIL collectives in the future?
Well, it's kind of an interesting thing because NIL has really morphed into something entirely strange. It's something that is very, like NIL in itself, just the concept of name, image, and likeness. It comes out of right of publicity. It comes out of the inherent right that we all have to our name, image, and likeness, and to prevent other people from exploiting our name, image, and likeness for money. It's not really a new concept at all. It's something that's existed for about 100 years, like just looking at the kind of the law. But in college sports, for one, because it's new and kind of has been given this NIL moniker, it is something that is very kind of new and very kind of fresh. But the way it's kind of manifested in college sports, because the NCAA hasn't allowed direct pay from universities to athletes, collectives have kind of stepped in where and this is exactly what the NCAA is trying to pare down on, trying to push back against, and the House settlement's going to allow them, to some regards, to be able to do this, is kind of these fake NIL deals that I think that's how they would describe it and how they have described it, where you're getting paid $500,000 to do a few tweets. Like, that's, in their eyes, it's not fair market value. Yep. It's not real. It's not something that's kind of legitimate when we think about NIL, when we think about Reddit publicity, which is you get paid a little bit to do a commercial spot, to do a commercial for any sort of brand. So we have Select Health behind us, for example. Like, if an athlete were to do a deal with Select Health where they get paid for it, that is what they consider to be kind of this true NIL. But when it's kind of funneled through collectives, and you're kind of, maybe the role of the college athlete in those cases would be to promote the collective, which is kind of circular in a weird little way. That's what the NCAA is trying to push back against.
Yep. You mentioned your time through law school, and through your now career as an assistant professor here at Boise State. How much of this did you see coming? I know that fans say, there was talks of in the 80s and 90s, and it kind of got pushed off, kind of came to a head with the explosion of the internet age, right? That's another thing that ties into it too. You got more voices, you have more outlets, you have more media, more attention. Thus, August 2021 rolls around, and the advent of the NIL era. How much of this did you see coming at the beginning of your career?
It's kind of an interesting thing where when I was getting my PhD at Florida State in sport management, I did my dissertation on kind of the history of legal challenges to the NCAA over amateurism rules, eligibility rules, and all that. And the way I like to describe it, and I think a good way of thinking about it, it was like kind of a huge amount of water kind of pushing against a dam, where there was all this pressure built up. There's all this momentum built up, where we had, for example, the O'Bannon case back in 2015. And similarly, we also had the Keller and the Hart cases, which were Reddit publicity cases, intellectual property cases, that looked at the NCAA football video games, for example, and NCAA basketball video games, for example, and said, well, the fact that these athletes aren't getting paid for this, and it's really this commercial thing for the NCAA, that feels under antitrust law and in a lot of other ways kind of fundamentally wrong. And all of that really kind of built up. It gave this momentum leading into Alston. And at the time we saw Alston, at this time that the Supreme Court accepted certiorari on the Alston case and agreed to hear the Alston case, the NCAA, well, they're the ones who appealed to the Supreme Court. They got what they saw as an unfavorable decision at the Ninth Circuit, and they felt that the Supreme Court was going to rule in their favor, and the Supreme Court was going to protect amateurism rules from antitrust scrutiny. And there was a lot of talk around that time. It's like, are they right? And in fact, the NCAA, this was in response to the California Fair Pay to Play Act in 2019 that said, we're going to force our schools to allow NIL, to allow players to profit off their name, image, and likeness. The NCAA had set up all these guardrails, and they had said, we are going to be able to do this. We're going to do this on our own terms. We're going to do this in a way that we feel is okay, and the Alston decision is going to support us. We're going to win the Alston case. We're going to be able to have protections from antitrust law and move forward from there. And then the NCAA lost 9-0, which that definitely threw a wrench in their plans. It was one of those things where the Alston decision was released on, this was a very busy day, on June 21st, 2021. And the first wave of state laws were set to come into effect on July 1st, 2021. So they had about 10 days to kind of react to that, where they apparently never thought they were going to lose that case. Yeah. They had about 10 days to react. They reacted as much as they could by essentially saying, everything we had planned before is no longer legally defensible. We need to pare this back, and that's what's really led to all this and led to a lot of different lawsuits, just a whole tidal wave of lawsuits now that the dam has been broken.
Yeah. Wow.
So I brought it back to the metaphor.
Yeah, no, that's good. That's good. That O'Bannon case hits close to home. I still play the old NCAA basketball games, and that's the reason why, right? Yeah. That was the genesis of it.
Absolutely.
The likeliness, I should say, related to the PS3 games. Don't worry, Bronco fans. I took the men's basketball team to the Final Four in one of those video games. So, no, I say that all digressing. But, getting to broad brushstrokes, you talk about the NIL era. You talk about the revenue sharing era. on the field, on the court, right? There might not be gigantic changes in what fans see. And I think that brings a lot of fans a lot of comfort and solace. But in your opinion, generally speaking, let's talk 5, 10, 15 years down the road, what major changes do you expect to see within the NCAA or within collegiate sports in general as related to this field?
I think there's going to be a major split between schools that want to do revenue sharing, that want to be more of a business environment, that we want to be more of a commercial enterprise, and the schools that want to go back and to at least as much as they can kind of to this amateurism era. And there's going to be a split there. And there already kind of is. Like we have Division II, we have Division III. Neither of those divisions are as affected by all this. I mean, these athletes have NIL deals. Some of these schools have collectives, but they're not raising millions of dollars. They're not paying their athletes millions of dollars or even hundreds of thousands of dollars. It still much more resembles what we saw before 2021, what we saw before this NIL era. But at the Division I level, there's really a wide discrepancy between schools that want to pay their athletes, want to have kind of this more quasi-professional environment and compete to win, and schools that are kind of looking at this and saying, well, wait a minute, we can't afford to be at this level anymore. We can't afford to do this anymore. In fact, just earlier today, we got the breaking news that St. Francis University has dropped from Division I. Literally 2 weeks ago, they're playing in the first four. They're playing in the NCAA tournament. Now they're going to be Division III because they felt like this revenue sharing environment, they just wouldn't be able to compete. It wasn't worth it to them to do that, and just their mission, what they saw their role, the role of their athletic department is much more resembling kind of that amateurism model, that intercollegiate sports model, rather than the front porch of the university. And I think that's gonna play out in a lot of different ways. I think it's gonna play out where we're starting to see, and I would imagine. I certainly wasn't in the room for this, but I would imagine a big part of our move to the Pac-12 was to say we want to compete with the big boys. We want to be on the quasi-professional side of this. I think that's a big part of why we're establishing Bronco Pro, a lot of those different things. And again, I'm not in the room for this. Please don't take me as speaking for the athletic department. But I think that's a signal, and I think all of that is a signal when Jeremiah talks about being with like-minded institutions in the Pac-12. That's what they're talking about. Yep. They want to be on one side of the line when everything else is when that split eventually happens.
Yeah, that's totally fair to say. One thing we took away from talking with Jeremiah and Cody last week was that Boise State Athletics as a whole was running into this era. It's not a lot of hesitation, and that's what the Bronco Pro program is currently working to establish for sure. What other things that maybe we haven't touched on today do you think fans really need to know about as they start to look at maybe the next calendar year of athletics getting going?
Well, one thing is just the continued, like one thing that I've been watching and one thing that I've found absolutely fascinating is the continued, and this is kind of another dam that's almost building in a lot of different ways, that we're seeing a lot of legal pressure in this area. And that's when it comes to eligibility rules. When it comes to the NCAA's 5-year rule, where you can play 5 years, including a redshirt year, and there's all these different exceptions to it. There's all these different waivers to it. That rule is under attack. That rule is very much under attack, and it'll be really interesting to see what the result of all that is. We have the Diego Pavia case, for example, back in December, where the court ruled that Pavia, by virtue of having junior college years, those junior college years can't be considered college years. They can't be kind of put up against Division I years. Yeah. He was going to get an extra year at Vanderbilt. And we've seen a bunch of other legal challenges right after that, kind of similar things as well. Nicer Forqueen at Wisconsin also won his case. And then you mentioned a baseball player before. You might be talking about either
Carrie Arboleda.
Who dropped his lawsuit, or Alberto Osuna, who is still very much fighting his lawsuit. That was kind of a weird decision where it's like we needed more information about this, and then Dylan Goldstein of Georgia, who lost his lawsuit because the court said, well, I mean, looking at the case law before Alston, these are not commercial rules. These are not rules that are impacted by antitrust law or shouldn't be impacted by antitrust law. And a lot of courts right now are saying, well, wait a minute, we have NIL now. This is a different environment. When we're talking about commercialism in college sports, these rules now have a commercial tint to them, and that's going to be something to watch moving forward. And The Pavia case is being appealed to the Sixth Circuit. The Four Queen case is being appealed to the Seventh Circuit. And those decisions are going to be absolutely fascinating and going to really make a lot of impact when it comes to the future of the NCAA's governance in college sports.
Are there any other kind of under the radar cases that you're following right now?
Well, one that broke last night, actually, one that, not necessarily broke, it was filed a few years ago, but one really interesting one, Fontenot v. NCAA at the District of Colorado. It was a case that was kind of set up as kind of the other House case or the other Carter case, really, where very prominent attorneys like Kessler and Berman are incredibly prominent attorneys. They've been in this space for a while. The attorneys in the Fontenot case negotiated a massive class action settlement with Major League Baseball for minor league baseball players. They just came to terms yesterday at a different case on a $46.5 million settlement with the NCAA for volunteer baseball coaches. They have experience in this area, and they are what they did is they kind of transformed this lawsuit to kind of the other side of house to now we are setting ourselves up as all the players who are opting out of house who say whatever the house settlement calculations are for their damages aren't what they feel their value is. We're going to include those athletes in this lawsuit. They consolidated with a different lawsuit that was going on. And looking at some of the names that were added last night, and they filed a new amended complaint that kind of set themselves up to be, if the house settlement is approved, they're going to go after for more damages. If the house settlement is rejected, they're going to push for class action settlement or class action status and kind of look to pick up where House left off. And some of the names that are in that amended complaint are really fascinating because they have a lot of value. Trey Lance is in there, former North Dakota State quarterback who played for the 49ers and the Cowboys. He was the first one that a lot of Major League Baseball players, NFL quarterbacks, like NBA players are in that. So that's going to be an interesting one to follow as kind of a supplement to the House case.
That's fantastic. Well, Sam, you've been extremely helpful when explaining some of this stuff today. If our fans want to follow you, your website or your social media, where can they do so?
Absolutely. My Twitter account is at Sam C. Ehrlich. Same handle on Blue Sky as well. That's where I really try to update a lot, or try to do kind of a lot of my updates. That's where I'm going to post a lot of my research. And that's just kind of a great place to reach out to me and kind of see what I'm doing. And there's also a link to my website, the College Sports Litigation Tracker, on there, or it's just collegesportslitigationtracker.com. And I think those are the best places to see what I'm doing.
Absolutely. Well, it kind of feels like we just scratched the surface today. So we definitely will be asking you on again at some point. But
please do.
Sam, thank you so much for your time today.
Of course, my pleasure. Thank
you for watching. Bigger thanks to Select Health for sponsoring today's episode. If you want to learn more about how you can simplify your insurance, you can do so at selecthealth.org. That about wrap up today's episode, everybody. Thanks so much for watching. And until next time, go Broncos.